Hernandez slapped a promoter at a club, and that the slap was either wearing a Ravens jersey or mentioned a Ravens player after the Patriots lost the AFC Championship. The promoter himself was interviewed, George Sarkis, and by the police, and he stated unequivocally that he was not slapped. He said he would, quote, 100% remember that if he Hernandez. So to permit testimony of a third party who says he saw something that the first party said he did not experience would be prejudicial. It would confuse the jury. It would lead to unnecessary litigation. And of course, we'd have to bring Mr. Sarkis in to complete the impeachment. And again, it would unnecessarily prolong the proceedings with no probative value. We also submit that this is another instance of the Commonwealth using secondhand information when the witness, the primary witness, does not say what the government wants him or her to say. For example, calling Ms. Ramos when Jaylene Ramos Diaz will not testify consistent with the government's theory, or trying to get several witnesses to implicate Chicago or say the name Chicago when Chicago himself will not testify consistent with the government's theory. So we think this testimony about the slap is inappropriate. There's a second issue with respect to Mr. London. It's not listed in the government's motions as a prior or subsequent bad act. However, when the government allocated about what it would, made a proffer about what it would elicit from this witness, they mentioned a notion of eliciting from Mr. London that there was a friendship between Mr. Hernandez and Mr. London that, quote, cooled off or turned dark. Let me say that according to all of Mr. London's prior statements, to the degree this happened, and we disagree that it did, it happened over a 1.5-year period leading up to the shooting in July of 2012. So this, whatever happened with a putative friendship between the two a 1.5 years prior to the shooting is not relevant to either the shooting in 2012 or the shooting in 2013. The only relevant period, it seems to me, would be after July 16, 2012. What London would testify to only serves to paint some sort of dark or ominous cloud over Mr. Hernandez and would, in effect, be nothing more than character evidence. As Your Honor knows from having reviewed the recorded interview of Mr. London, the accounts are wildly inconsistent. His first interview states that there was no friendship, nothing at all outside of a business relationship, and he says that several times, and he says it unequivocally. Third, Your Honor, with respect to Mr. London, is the issue of the snitch or fed comment. The first point I'd make here is that either Mr. London does not remember the date, or he would be asked to speculate or guess about the date that the snitch or fed comment was made. If the comment was made before July 16, 2012, then that is not consonant with the government's theory that the snitching regarded the July 16, 2012 issue, and it would seem wholly irrelevant if that's the government's theory. Nor, importantly, is it consistent with the government's theory that Mr. Hernandez was somehow aggrieved by people trying or testing him. That's the other government theory. Calling someone a snitch doesn't at all relate to being tested or being tried in the way that the government has put on evidence to it. Presumably, this would be some new theory of prosecution, and we submit that it's too late from that. To the extent the government argues, and it made some gestures at an argument that this goes to some sense of paranoia of Mr. Hernandez. Any evidence regarding paranoia from the 7/16/12 event would have to be caused by the 7/16/12 event. That's the event which putatively gives rise to the paranoia. General paranoia before the 16th of July 2012 is one, is a medical diagnosis and would require some expert testimony. But two, it is wholly irrelevant to any material issue in this case. If the government is claiming that the comment was made after the 16th of July 2012, the jury would have to be force one to guess whether it did happen after, because the witness is unclear. Further, the jury would have to guess and speculate as to why Mr. Hernandez would have called Mr. London a snitch or a fed. The terms are susceptible to very many different meanings, and there's nothing about anything that Mr. London has said in prior recorded statements that clarifies the meaning. And actually, let me drill down on that a bit. There is one thing that Mr. London said that provides some context. Mr. London was definitely afraid of the notion that as a promoter, he clubs and how and whether celebrities might do drugs and that sort of thing, and that's part of his reputation. So when someone calls him a snitch, he said to the promoter that this is, I'm sorry, to the law enforcement that this is my career. If people think that I'm telling what celebrities do in these clubs, then that's my reputation. They will stop calling me. Is there any way you can keep my name out of the media? So that's the thing he was concerned of, not snitch or fed in some criminalized sense. But the broader point, Your Honor, is this. The jury would be forced to speculate as to whether the meaning of snitching is because is because, you know, maybe he was telling people that about Mr. Hernandez's conduct within clubs and how he partied and that sort of thing. Was it because Mr. Hernandez's former friend, Alexander Bradley, was bringing blunts, large marijuana cigarettes into the club? Was it because London had a reputation for talking to media about celebrities? There were specific questions about a Rolling Stones article, whether he was the leak in conversations with law enforcement.
Wasn't that after Lloyd?
Yes, Your Honor. The point is, the more general point is he was worried about whether London was worried about whether London might have a reputation.
Yeah, but the point is not what London thought. We're not focused on London's state of mind with regard to this evidence. We're focused on the defendant's state of mind.
And the jury would have to absolutely speculate as to the defendant's state of mind, because there is nothing about the context of any of these statements that suggests that the reference, even if believed, would be to the 7/16/12.
We agree, I take it, that although the time may not be certain, it is certain that the so-called fed or snitch accusation occurred before February 13 of 2013. Correct?
Before February 13th? He doesn't know. The witness doesn't know.
Well,
yes, Your Honor.
We know, don't we? We know because...
2013, I'm sorry.
Yes.
Yeah,
London's
yes,
account
yes,
is
yes,
that
yes.
Bradley was with Mr. Hernandez.
Yes, my apologies. I heard 12.
No, the 13.
Your Honor, if I could just provide some timing context. I'm not sure if Mr. Sullivan saw the email that we sent this weekend, but we do have a little more clarification from Mr. London as to the timing. Mr. London and we did provide to the court as well a copy of the email we disclosed to counsel. Mr. London, again, has always been consistent. It happened at around the time, the summer of or thereabouts of 2012. Mr. London, when asked if he could be a little more definitive, he did recall that Mr. Bradley or another man was wearing a leather jacket at the time that he was walked out to the car. And he had a distinct memory of that. He also had a distinct memory that this incident, the Fed or Snitch incident, happened during the last year of the time in which he interacted and knew Mr. Hernandez, which would go obviously until about June 20th of 2013. So based upon those two memories that Mr. London distinctly recalls, he is now under the impression that the Fed or Snitch incident happened after July 16th, 2012. Again, his only reason for thinking it could have been before was based upon the fact that he didn't walk them in, but he also acknowledged in his early statements and acknowledges today that he's on the phone when they walk up, and that could be a reason why he didn't leave them downstairs. So again, I think the evidence, if allowed to testify to it from Mr. London, would be that his memory is that the incident happened after July 16, 2012.
And again, even Mr. Hagan's vocabulary, it could be this. I think it must be that because of the witness would be required to speculate as to the date. But even importantly here, Your Honor, even if Your Honor were to permit this witness to testify that the date was after July 16, 2012, the range of potential inferences with respect to what snitch or fed means is so vast in the particular context of this business that it would invite the jury to improperly speculate. But as a predicate matter, it's too unclear with respect to the date, and that the government and the police interviewed him again a few days ago. I did see that, Your Honor, but this constant refreshing recollection of witnesses who do not have a memory consistent with the Commonwealth's theory continues to prejudice Mr. Hernandez.
Okay, got it. Now, did you say you have challenges to other witnesses?
I do, Your Honor, and if I can be heard briefly on those. With Mr. London, there are 4 areas that we're challenging in the testimony. I just want to be clear that we have all of those. 1 is the slap, 2 is the nature of the friendship a year and a half before.
Yeah, you've argued that.
Yeah, I just want to make sure Your Honor has all 4 in mind.
Well, I have 2 instances that you've referenced.
2 instances, the slap and the snitch fed comment. The government hopes or intends to elicit notions about their friendship a year and a half before, and then this notion of it turning dark is the 4th. We think that those are irrelevant. They all would have happened before the July 12, 2016.
All right.
Your Honor, there's an additional one. I don't know what counsel's position is on this, but we mentioned on Friday, and it was disclosed in statements as well as grand jury and alluded to in our prior bad acts. But Mr. London did also observe verbal altercations that Mr. Hernandez had with patrons during the time period as well. So I don't know if that's something that counsel's not objecting to, but that's part of what we represented on Friday.
We are objecting to that. It's to my thinking, that's not part of their initial motions, some random verbal altercations. But to the extent that the government wishes to elicit that, then we would object on similar basis. The law in the Commonwealth is clear that evidence elicited just to show that a defendant is a knave, a bad person in general, is inadmissible and it's prejudicial.
All right. I'm going to allow London's testimony, and I will rule as I hear objections during the scope of his testimony, or course of his testimony. If the defense feels it helpful, before he testifies, I'll be happy to give a limiting instruction with regard to the appropriate use or consideration of this evidence, not to include any consideration relating to character or propensity. Is that an instruction that would be appropriate?
No.
No.
No, Your Honor.
You don't want an instruction?
Do not.
Okay.
Is this with respect to all 4 areas?
Now, as to other witnesses, do you have any? You referenced other witnesses.
Yes, and just to clarify, is this in respect to all 4 areas you're permitting inquiry?
I'm going to rule as he testifies.
Very, very well. Yes. With respect to Mr. Hernandez's older brother, DJ Hernandez, we expect that the government is going to call Mr.
He's not being called today.
Is he not?
I've got the jury waiting. Let's deal with the witnesses who you have a concern about today.
If the court can inquire of the government whether Oscar Hernandez is going to be called today.
Well, he's on the list that you have received.
As was DJ Hernandez, Your Honor.
No, he's listed for tomorrow.
I guess the court has my list. I have a list that has
I
Hernandez.
have your list?
So, may I speak with respect to Oscar Hernandez?
Yep.
So,
Quickly, please.
pardon me?
Quickly.
The admission of evidence offered by Oscar Hernandez, and this is with respect to guns in an automobile that the government intends to elicit. Our position is that the admission of this evidence has little to no relevance, and any relevance is substantially outweighed by the potential prejudice.
All right, hold on, Mr. Sullivan. Let me get a proffer from the Commonwealth as to what it is Oscar Hernandez is being called to say. Was he down in Florida?
He was, Your Honor. Essentially, Mr. Hernandez's testimony that I don't believe is being contested would be that he arranged the Super Bowl party that Mr. Hernandez attended with Mr. Bradley. He will provide significant background, Mr. Bradley's presence with Mr. Hernandez at various events. He will then be expected to testify that at some point another part of the group, an individual named Deontay Thompson, had requested a firearm for protection, that Mr. Hernandez, Oscar Hernandez, provided a firearm to Mr. Thompson, and then he picked it up the next day in the hotel room where Mr. Bradley was staying. This would corroborate Mr. Bradley's testimony regarding the black semi-automatic handgun that he saw in the hotel room. Some other various aspects of the time in Florida. That's essentially the uncontested, I believe, testimony of Mr. Hernandez. What I believe Mr. Sullivan's referring to, Your Honor, and we could probably address it somewhat during the morning break or perhaps even after during the luncheon recess, because Mr. Hernandez is requesting immunity at this time and we're getting all the paperwork as we speak. I think what Mr. Sullivan is referring to is the Commonwealth did put in our motion for subsequent bad acts. Again, depending on how the evidence played out, the possible bad act that Mr. Oscar Hernandez did in fact plead guilty in federal court to shipping an assault rifle as well as 2 weapons, one of which was believed to have been used in the Odin Lloyd homicide, to Mr. Hernandez in May and June of 2013. In fact, the Toyota Camry was searched pursuant to the Odin Lloyd search warrant at Mr. Aaron Hernandez's house, and they did recover the assault rifle with Mr. Hernandez's palm print on it.
All right. Were you listed that as one of the other act incidents that you sought to introduce,
Right.
including the recovery of that semi-automatic rifle. Are you still advancing that claim?
Well, had you asked me some time ago, I don't think we would have been advancing it. I do have one.
I'm asking you now.
Yes, but only
How
for
is
one
that
purpose.
admissible?
Only for one purpose, Your Honor, and I recognize it's a little bit of a stretch, but this court did allow, over objection by the Commonwealth, cross-examination of Alexander Bradley regarding whether or not he in fact had a MAC-11, a MAC-9, other assault rifles. Over the Commonwealth's objection, again, the Commonwealth concedes we put in the text message where he referenced those, but we never intended for there to be inquiry as to whether or not Mr. Bradley actually possessed those. This court, over the Commonwealth's objection, did allow not only testimony about Mr. Bradley purchasing those, but also photographs of these rather ominous-looking weapons. Again, under the concept of the court being fair to both sides, the reality that the jury, I think, has a right to know is that both Alexander Bradley and Mr. Hernandez essentially were arming themselves, presumably ostensibly to battle with one another over the dispute of the Florida shooting. So the Commonwealth's position is that it's somewhat unfair to the Commonwealth to allow that evidence in against Mr. Bradley without allowing in similar evidence of Mr. Hernandez, that he too was arming himself with assault rifles. Again, but for that fact of Mr. Bradley's...
All right, got it. Mr. Sullivan, you need not argue that point. I will not allow evidence as to Hernandez shipping a weapon or as to that weapon .32 millimeter semi-automatic rifle being recovered from the defendant's car in June of 2013.
Very well, Your Honor. There's a witness named Jarrell Pierre
Yep.
on the witness list for today. Pierre's prior recorded statements all indicate that he does not recall the events surrounding February of 2013.
Yep.
Does not recall staying at a hotel before the Super Bowl party. Does not recall picking anyone up from the airport. Does not recall being introduced to Mr. Hernandez's friend, presumably Mr. Bradley. Doesn't even recall going to the Tootsie's nightclub, and does not recall being in a car where someone was shot. Indicated in prior recorded statements that he heard about Bradley shooting in the paper. There are no prior inconsistent statements by this witness at all that we've been provided, let
All
alone
right, so the
ones.
objection is what?
The objection.
That he has no evidence to provide.
He has no evidence to provide, and the only purpose of calling this witness would be for the Commonwealth to, in effect, testify, to ask questions that they know he's going to say, I don't recall, I don't have any answers to. It would be
Was he
prejudicial, mislead the jury.
Was he supposedly in the vehicle?
In accord with the government's theory, Your Honor, that's the theory that the government is advancing.
And isn't it Pierre that you are asserting was the shooter?
We
That
have
in
not,
fact Pierre shot Bradley?
we've not put on a case yet, Your Honor.
Isn't
And we
that,
never made that assertion in any.
wasn't that representation made to me? That Jarrell Pierre retaliated against Bradley for Bradley's shooting of Mr. DeBreo and Mr. Furtado?
No,
No?
no,
That representation was not made.
no, indeed it was not.
Isn't that what Mr. Leontier argued with regard to gang signs? And some indication that Jarrell Pierre was seen on social media making a hand gesture that you were attributing to the Cape Verdean Outlaws, such that Jarrell Pierre was a member of the Cape Verdean Outlaws and shot Bradley in retaliation.
We never said he shot Bradley in retaliation. I do remember the arguments about the relationship to the gangs, but in any event, we have
No,
not.
that representation was made at sidebar as part of an offer of proof with regard to so-called gang signs.
Well, we can look
I
at
asked
the
you to
transcript.
put that into writing with regard to a foundational showing of the basis for that claim, and the defense declined to submit anything in writing. But the defendant asserted that Pierre was involved and his involvement would be relevant to this case.
For the record, the defendant hasn't asserted anything, Your Honor. The defendant
No,
hasn't
Mr.
decided
Sullivan, what
whether to
you
put on the case
repre-
yet.
Are you done?
Well, if Your Honor keeps interrupting me, then of course I'm done.
All right, then be done. What you represent at sidebar is something I can rely on in making rulings.
And I'm saying I did not represent it at sidebar. And we should just go to the record then.
The defense did not? I don't care
That was
what
not
you
our
said.
representation.
I don't care what you
Well, you
said.
just said I
It
said.
is what the defense team that you are speaking for said to the court.
We made a representation about gang signs, Your Honor. We did not make a representation about Jarrell. And even if we did, it's
You
still
most certainly
irrelevant
did.
to this issue.
Okay. I will listen to any objection as Pierre testifies. Do you have a challenge to anyone else, sir?
So for the record, Your Honor,
As to anyone else, Crawford or Thompson or Deputy Davis?
so the ruling of this court is that I cannot make any further representations about Jarrell. I'd just like to know that.
No, I've heard you on Jarrell. Now,
So
as-
Your Honor's ruling is I cannot say anything else with respect to.
you may
Jarrell.
object as he testifies. As to the others, sir.
So in light of the fact that Mr. Hernandez is being denied his Sixth Amendment right to make representations with respect to witnesses who have nothing to add to this trial and who will do nothing but prejudice his interests, I will move on to the next witness. Next witness is Tyrone Crawford, Your Honor.
All right, let me just hear a proffer as to what Crawford is being called to say. What is Crawford going to add?
Crawford is part of the group of Florida friends of Deontay Thompson. He will testify generally consistent with Oscar Hernandez as to the timing of the Super Bowl party, the various events, the various times that they went to nightclubs. In particular, Mr. Crawford will testify that he was present with the defendant and Alexander Bradley and Jarrell Pierre at Tootsie's nightclub on the early morning hours of February 13th, 2013. He will indicate that they did get into a car after Tootsie's. He will indicate the seating positions consistent with Mr. Bradley's testimony, but he will testify that he got out of the car prior to the shooting and then re-entered the car sometime later. Mr. Bradley was no longer there. Everybody was acting silent, and that's essentially the scope of his testimony.
All right. With that, by way of proffer, Mr. Sullivan.
I just want to note for the record that this court does not interrupt the government. The government makes proffers. This court does not interrupt the government. This court does not say, "Are you finished?" This court does not say or suggest by its statements or its conduct that the Commonwealth is wasting this court's time. When I am representing someone who faces a mandatory sentence of life imprisonment for 2 double murders, and this court consistently cuts off this team, consistently makes references that what we're saying is either unimportant, frivolous, or taking up too much of this court's time. And I think it's unfair. It violates the due process clause. It's an indication of judicial interference that is inappropriate. That is inappropriate. I've never been in a court across this country where the court consistently interrupts one side. Consistently does that. It's inappropriate, Your Honor, and I'm going to request that this court treat us in the same way that it treats the Commonwealth.
Make your succinct arguments, and you will not be interrupted.
Well,
As to Tyrone,
I submit that my arguments are succinct, Your Honor.
Right.
He has a Sixth Amendment right to be heard on these
and
cases.
he has been heard. I don't know any murder case where I've heard more from counsel in pretrial and trial proceedings than this case, Mr. Sullivan. As to Mr. Crawford, what is the issue?
And Your Honor has said that several times before. I have nothing to do with what other defense attorneys do in this courthouse. I can only represent him, and I can only do that to the best of my ability. If other people do not behave consonant with their Sixth Amendment obligations to represent their clients, that's on them. I'm not going to do that. I can't do that, and I won't do that. Now, if the court orders me to stop talking, I'll sit down now if the court has a decision
I'm
already
asking
in
you
mind.
to talk, please. I'm asking you to talk to Tyrone Crawford in the context of the proffer that the Commonwealth has given as to what he will say. Do you have any challenge to that
In the
testimony?
context of that proffer, we're not going to make an additional challenge. We'll make objections
Okay.
at the time the witness testifies.
All right. And as to Mr. Thompson, is there a proffer as to Thompson?
Yes, Your Honor, just very generally, Mr. Thompson hosted the Super Bowl party. He will again place the various parties present, including the defendant, including Mr. Bradley. Mr. Thompson was not present on February 13, 2013, when they went to Tootsie's. He was somewhere else, but again, more general background information. He will testify inconsistently with Oscar Hernandez and will indicate he did not have a firearm in the hotel room.
And let me ask the firearm that Hernandez is going to talk about. And that's a firearm that Mr. Bradley testified to seeing. Hernandez is going to say that he obtained that firearm and gave it to Thompson, correct?
Correct, it's his firearm, Mr.
Is
Hernandez.
anyone going to describe the caliber of that firearm?
Mr. Oscar Hernandez, it's his firearm, so it's a .40 caliber.
Consistent by caliber with the shell casing that was recovered on the street.
Correct.
Is it the Commonwealth's suggestion that that was in fact the weapon used to shoot Mr. Bradley?
It's a Commonwealth's suggestion that that could have been the weapon to shoot Mr. Bradley.
And Thompson is going to deny ever having a weapon.
Correct.
Does the Commonwealth believe that?
But those two individuals, Mr. Thompson and Mr. Hernandez, are close friends from growing up in the same town. So clearly, one of the two individuals is not being forthright, perhaps both.
Let me see you all at sidebar.